Trying to get them after watching however many.
Welcome, everybody.
Yeah.
Welcome, everybody, to House General and Housing. It is Thursday, April 3rd, still. And we are taking testimony on H 429, an act relating to the jurisdiction of the Human Rights Commission. And our witness is Damian Leonard of Legislative Council. Damian, take it away.
Thank you. Good afternoon. For the record, I'm Damian Leonard from the Office of Legislative Counsel. It's a treat to be back in this committee. I had feedback. Sorry about that. There we go. So I'm here to talk about H 429. So
I explained to them what each of the panels do. I explained to them about the ethics panels versus ethics committees, or the state ethics committee. And then I tried to explain to them obliquely about what happened last year. And I thought it would be easier for you to explain in a legal context.
Sure. So before I start my testimony, let me be really clear. So I worked as not only legislative counsel for labor and employment issues, but I also provided counsel to the House Sexual Harassment Prevention and Discrimination Prevention panels. I cannot discuss any cases or even confirm or deny whether they existed. So I can't discuss specifics or answer questions about those things. What I can say is that we did have discussions within the panels last year about what the options were if someone had a complaint and they didn't want to go through the panel process. And the options are, they depend a little bit on whether you're a legislator or an employee of the General Assembly. And we're dealing with two statutes here. One is the Public Accommodations Act, and the other is the Fair Employment Practices Act. So for myself, if I experience discrimination within the State House, my claim would likely be under the Fair Employment Practices Act, because it would likely be in the course of my employment. So the question would be, did the General Assembly or someone acting as my supervisor either discriminate against me or not take actions to ensure that I was protected from discrimination? And this would apply to any employee in the building. Under the way the law is written, you have, well, one, we have our policies here, so I can go to our Human Resources Department, or I could bring a complaint. Let's say the harasser or the person engaging in discriminatory conduct was a member of the House. I could bring a complaint to one of the House panels and ask them to resolve the situation. As you might imagine, for some employees, it could be intimidating to go before a panel of House members to allege that a member of the House had discriminated against them or sexually harassed them. So this is essentially the question, what led to the question of, well, what are the other options? And typically, if you're an employee of a state agency, you could either bring a private lawsuit, which you have to find an attorney willing to represent you, and there is some risk, there's costs involved, et cetera. Or you can go to the Human Rights Commission. So they have jurisdiction over claims against state agencies. And I'll pull that statute up in a second, because that's really what H 429 would be looking at. And the question, though, in the case of a legislative employee is the General Assembly a state agency? And it's not clear to me, and this is really the genesis of that conversation, it's not clear to me, and And there's disagreement among the attorneys I've talked to about this, about whether state agency encompasses the General Assembly. And so the question is, if I don't have that right, and I can't go to the assistant attorney generals because they would be, the AG's office would be defending the General Assembly. They can't also bring the complaint against them. So that leaves legislative staff and employees with the private right of action or going to the panels or human resources. So there are remedies. It's just there's the possibility that there are not as many remedies. For members of the General Assembly, you don't have an employer-employee relationship. You could maybe make the argument that you do because you get a stipend for your service, but you're elected by the people of Vermont, and your service within the building is subject to House rules. And in the past, when there have been complaints under employment statutes, not in Vermont, but in other jurisdictions, when members have brought complaints under employment protection, discrimination protection statutes, courts have often dismissed those as political questions, saying that's within the chamber's regulations. The statutes don't cover that. You're not an employee in the traditional sense of the word. So that brings us to the Public Accommodations Act. And the Public Accommodations Act, I'll pull it up for you here because I think reading the words will help understand what we're talking about here. So whenever it gets up there.
There.
All right. So with the Public Accommodations Act, so an owner or operator or an agent or employee of the owner or operator shall not, because of the long list of protected classes, refuse, withhold from, or deny to a person any accommodations, advantages, facilities, and privileges of a place of public accommodation. So how does this encompass members of the General Assembly? The answer here is that potentially in a discrimination claim, a member of the General Assembly could argue that the advantages and privileges of the State House, which is this place of public accommodation, have been denied to them in their capacity as an elected member. That being said, you would have to potentially prove under that you are unable to carry out your job as an elected member in order to bring a claim under this. Again, though, the question is, where would you bring the claim? And for a member of the General Assembly, your remedy here is really, so typically these public accommodations claims would often go to the Human Rights Commission. But again, Human Rights Commission, here there's a little bit more of a clear connection, but again, this question has come up about the jurisdiction. So I think there is potential for a member to bring a claim. Now, this isn't the panels bringing the claim on behalf of the member. This would be a member would have to decide. And maybe, so an instance when this might happen is the member might say, I don't feel like I'm going to get a fair hearing in front of the panel for whatever reason, whether it's perceived biases or whatever it is. Where else can I go? And so the genesis of H429 came out of these questions of what is the jurisdiction of the Human Rights Commission and does it encompass the General Assembly? If we turn to the Human Rights Commission's role, I'll pull up that statute for you in a second here. Flipping between pages here while I'm off screen. So it really, with the Human Rights Commission here, let me pull up that statute, and it really comes down to these employment practices claims. So it's really about the staff of the General Assembly here. And the question is, so complaints of unlawful discrimination and the Fair Employment Practices Act and the provisions of workers' compensation discrimination shall, whoops, nope, that is not, it's the one above it. Sorry, guys, I'm a little rusty. I've been away from these statutes for 6 months. So in any case relating to unlawful discrimination or sexual harassment in violation of 21 VSA 495, that the commission has jurisdiction over pursuant to this section. Nope, sorry, we're getting there. Here we are, B1. Commission shall have jurisdiction to investigate and enforce complaints of unlawful discrimination in public accommodations and rental and sale of real estate. So that's the Public Accommodations Act. They've got jurisdiction over that. And then the commission shall also have jurisdiction when the party complained against is a state agency in matters for which the Attorney General would otherwise have jurisdiction. And so the Attorney General has jurisdiction to investigate and enforce the Fair Employment Practices Act. However, since the Attorney General represents the state, in cases with state agencies, it goes to the Human Rights Commission. So there's a neutral third party. In cases with the General Assembly and potentially with the judiciary or with elected officials who are not a state agency, potentially, it's really a question of how broadly you read that term. If you read it narrowly, we're talking about, agency of education, agency of human services, and then the departments underneath those agencies. And then the question becomes, can you read it broadly enough to encompass the General Assembly, the judiciary, the Office of the Treasurer, the Defender General, the state's attorneys, the governor, et cetera, the auditor? You start thinking about these offices that are not state agencies in the express term. And the question is, does state agency include those? Should that be clear? And what I would say is, my reading of this is that it's not clear. And in talking to other attorneys, I've gotten differing opinions. Yes, I would read that to include them because it's a remedial statute. And typically we read those broadly to remedy the harm, or no, state agency means one thing and those are something else. And so the question that's at the heart of the bill, if I can speak for Representative Burrows, is this issue of where's the jurisdiction lie and do we need to clarify the jurisdiction? I would say that I would encourage you to hear from the Human Rights Commission and other affected entities if you decide to move forward with this. And our conversation really came out of that question of where would people go if they chose not to go to the panel or something like that. So
wasn't there combining that with some other reflections on the last biennium? Was there, because it's burned into my mind. Please help me to recognize if it is burned wrongly into my mind, but doesn't the legislature enjoy qualified immunity? I recall you saying that all of the rights that legislators have are given to them.
Qualified immunity, I think, is not the right term. So there are privileges you enjoy as a legislator. So legislative privilege is something you can assert for privacy purposes to keep communications that were made in the course of doing your legislative work private, things that are helping you sort of reach your own private conclusion about how to vote on a bill or how to do your job within the building that aren't a floor speech or a public discussion here. So there is some legislative privilege. There is attorney-client privilege. there is also protection for, there are some protections around actions you take on the floor in the course of your legislative duties. So,
I was thinking more about the discussion about accessibility in the State House, and how the because I remember there being a discussion about how qualified immunity meant that that the case, the Supreme Court case, meant that the legislature is not necessarily
yeah.
beholden to the ADA as it.
So there is a case on that. Let's take the term qualified immunity out of that.
Okay.
Because I think that term is being conflated
Okay.
with the right holding, and it also raises all sorts of flags about questions about other sort of official conduct. There was a case in the First Circuit during the COVID-19 pandemic. So there were members of the New Hampshire legislature who brought a lawsuit under the Americans with Disabilities Act against the Speaker of the New Hampshire House because the Speaker did not make the accommodations they had requested. And these members had various conditions that weakened their immune system. And so they were concerned about having to go into a group setting that Vermont went remote, New Hampshire did not. Instead, they met in large areas, but these members argued this is not safe enough for us and you're impairing our ability to do our job. So they brought in an argument under the Americans with Disabilities Act that they were not given a reasonable accommodation. That case went up to the First Circuit Court of Appeals. So this is persuasive, but not binding on Vermont because we're in the Second Circuit. And what the court there essentially ruled is questions of how the New Hampshire legislature conducts itself are a political question, and it's not appropriate for the court to involve itself in the internal conduct of the legislature. Similar holdings have come up in our state unrelated to Disabilities Act and discrimination, but where people have questioned the way a vote was counted in the House floor or something like that. There was an instance where there was a pool around a certain bill on how many votes for and how many votes against. And the outcome of the bill was challenged on the basis that members had an interest in the outcome. And the court said, no, we're not going to undo the outcome because of that. Again, that's up to the House itself to govern the conduct of its members. So this has come up in the context of whether or not if a member of the House or the Senate here in Vermont needs a reasonable accommodation to do their job, and the chamber declines to provide them with that reasonable accommodation, could the chamber be held liable? And potentially, because it's part of the legislative process, the chamber would, for want of a better word, be immune from a lawsuit or from being held liable in that lawsuit. But it's not for sure that the Second Circuit or Vermont Supreme Court would follow that precedent. It is a persuasive precedent that we did discuss in the context of accessibility to the building and concerns that have come up about that and who could bring claims. A member of the public can always bring a claim under the Public Accommodations Act against the General Assembly. And then there's a different set of considerations that comes up around whether it's a reasonable accommodation and so forth. But we are subject to both state and federal law as far as providing accommodations to individuals, members of the public who have a disability, and allowing them to participate in goings on in the building.
Damien, as I understand it, the issue in front of us is is whether we should resolve the ambiguities that you've been telling us about through legislation.
That at the core of it is the policy question. And you may get a different opinion on the ambiguity from a different
But
attorney.
in a way, it's
So-
harm. It doesn't make any difference. Because if there's an argument that it's ambiguous, then that's an argument for legislation. The fact that there's disagreement over the ambiguity only confirms that it's ambiguous. So the question is, in front of us is, what should the legislation say? And in that regard, I just want to confirm my understanding. Disciplining ourselves is up to us. No other entity can do that.
Right.
So, but we can consent to assign to the Human Rights Commission that task.
You can consent to give the Human Rights Commission jurisdiction, yeah. I
Right,
don't think you could. I think there would be a valid constitutional claim if you let them interfere with the internal regulation of the House. But to give them jurisdiction over employment discrimination claims, that I think gets to a different issue where you've kind of consented to.
right. So the question then, the policy question is, number one, do we give them just jurisdiction to investigate and recommend? Number two, do we give them jurisdiction to the full panoply of jurisdiction, which would mean the right to conclude that there'd been a violation and bring a case in Superior Court?
Right, and it's worth noting, and the executive director at the Human Rights Commission can give you a much better overview than I can, but it's worth noting that their approach is often to seek a settlement
Sure,
once they've found that before going to court.
right. But we could define, could we not, what that was? The one that worries me and that I don't know the answer to does not involve us granting HRC jurisdiction over us. It's us granting HRC jurisdiction over another constitutional officer. And my question for you is, doesn't that violate separation of powers?
It's a good question. And I don't know that I've thought about it enough to have a clear opinion for you. So I'm sorry, I don't have a good answer, but I think that would certainly be a question that's worth looking into further before you take that action.
How would we look into
Well,
that?
that's what I was gonna.
Yeah,
say.
I mean-
wonder if we have like, what's that constitutional guy come in? Yeah.
Reach out.
You could ask him to come in.
Yeah.
So
Thank you.
so I don't want to volunteer my colleague for more work. But
Which one do you have in mind?
Sophie, who drafted this bill.
Oh,
Sorry, she's totally
She's ours.
volunteered.
She's
We
ours.
know her.
But it was based
Um,
on the bill that you drafted last year.
Right.
so.
So, yeah, and it's, this is the sort of thing we can research and give an opinion on. It's also something that I'm sure other entities that would be involved would have an opinion on. To some extent, we do regulate conduct in other branches, but it's also, there are often questions of, are you going too far in inserting yourself in the affairs of these other branches? And it's worth noting too, that there is a constitutional tool for disciplining a constitutional officer. It's impeachment.
Right.
And it is rarely used and very difficult. And that's the way our Constitution set it up. So there is that question of, and it's one that I have not looked into or thought through thoroughly of could you pass this legislation and would it stand up to a constitutional challenge if you were subjecting you to besides the General Assembly?
Too.
Yeah, I mean, that's what I'm wondering. I support this concept and bill and have, under the idea of closing a loophole where there's accountability for a statewide elected official who's not in our body. I think that what I'm wondering if you're saying that like. If there's a claim, then they could bring it up to an impeachment. That seems like too far. That would be a whole ordeal, cost a lot of taxpayer dollars, a lot of whole thing, that's too much. But some other way to determine, I mean, maybe it would come to that if it was found to be something that deserved that. But to go through that process as the step would be too much, in my opinion. Does that make sense?
Yeah, there has to be an intermediate
Right,
step.
That
right,
is a policy question.
right.
Right.
There is a legal question in there. And if we want to, I mean, I'm trying to speak now as chair. We have this bill in front of us. We're taking testimony on. We have to we have to give instructions
Right.
to your office to develop the bill, since it's a short form bill.
Mhm.
And that means we need to know what the constitutional boundaries are. So I would say to you now, I mean, I don't know whether we also, does the Attorney General give opinions?
Historically, they have. And I mean, yeah, historically, this is something that our office
Your office?
would research, but historically, the Attorney General's office has also given opinions. They used to give a lot more of them before Ledge Council existed.
Huh.
But I'm sure they have their own opinion.
Well, I would say.
I'm sure the Human Rights Commission does too.
But I would say that we need to know, you have various different loyalties. As you started off, the first thing you said, well, I have loyalty to the panel and there's certain things I can't divulge. But now here you are, this bill is in our possession. It's not even in the author's possession, it's in ours. And so you're our lawyer. So I think I'm safe. And I'd like, without objection, if there's objection, I would like to ask you for an opinion on the constitutionality of our being able to A, simply give them the power of investigation, or B, give them the full panoply of their statutory powers with respect to constitutional laws.
Okay.
Is that acceptable?
It is. It occurs to me as I'm thinking about this that I am going to guess that we had similar research done when we created the state ethics panel about what we could and could not do there. So if you don't mind us taking a little bit of time to dig into this, I think this is something we can do. I'll touch base with Sophie and then with the attorneys who worked on the ethics panel. If it's okay with you all, I would also touch base with the House clerk because she has a lot of experience in
That's
this area. And then we'll put together an opinion for you and we'll come back and let you know what the potential pitfalls are, what the potential limits are, and then you can consider how to move forward. And I would say that, like you've sort of highlighted here, it is a more clear question if you're giving essentially giving or granting the right to sue through the Human Rights Commission to sue the legislature. It's a much more clear question there. So that's similar to the sovereign immunity sort of question.
Well, that gets me to a second request.
Mhm.
And then Joe, I know you've got your hand up, but I just want to get these out. So we're asking you for an opinion on the question of the jurisdiction of the HRC. Should we grant it with respect to constitutional officers? Then there's the question, which is more a policy question for the committee. We can direct your office to draft the full bill with respect to ourselves, delegating to HRC our own powers. I'm suspecting that we're not ready to give them direction yet, that we need to hear from the HRC and possibly others before we do. And I just want to confirm that, but that's up to us. In other words, Damien has clearly stated that the current law is sufficiently ambiguous that we cannot rely on it safely. And therefore, I mean, the fact that there is, I don't want to repeat myself. Okay, we can't. So the question is, well, what do we want them to draft? And there are several different options, but I don't think we're ready yet to decide that. But that's what we'll have to do. If we want to pursue this bill, we have to say, okay, what we want is this. Damien, please write it so that it's constitutional. And am I right? Do we want to wait a little?
Yeah.
Yeah, I think that's good.
Okay, Joe, I'm sorry that I
No worries.
jumped in there.
I forgot what I was gonna ask. No,
Oh,
I talked long enough, you'd forget.
it's earlier, did you say that there are currently remedies, but if somebody didn't want to go that route for reasons?
And that's, yeah, there are currently remedies. So again, if I or another employee experience discrimination or sexual harassment in the course of my job here, I have in-house remedies. I have the HR team, I have my boss, and I have the panels if it's a member of the house or someone who's employed directly by the house, like someone in the clerk's office. In addition, I can also, clearly under current law, I have the right to bring a lawsuit to superior courts. And the courts do have jurisdiction to hear a violation of the law. You know, so there's the old saying, no one is above the law. So that applies here. So with a lawsuit, it would be a little bit interesting because who's the entity who's defending? Likely it would be after exhausting my ability to try to fix it in-house or being able to show that, say, the person discriminating against me was in such a position of power that they were essentially acting on behalf of the body as a whole. But then I'd be suing the General Assembly.
we don't
and
have any
then-
money.
Pro bono.
It's interesting that you
We've got
say
a-
that. Yeah, the courts have not recognized that, even during recessions and
That's because
economic downturns.
Right.
Yeah, that is, that's not a winning argument.
All right.
Wouldn't that throw you back though into the political question?
No, so there's a difference between the Speaker of the House saying we're going to meet here.
Oh, that's because you're an employee, right? Okay.
Right. So versus an employee where, you know, the speaker has an obligation under the law that the House passed to provide me with a workplace that's free from
But
discrimination.
go back over Joe's question. So if you're an employee, you have remedies. You've got panels, you could conceivably sue, you have panels, and you have
The-
HR. But as a member,
As a member, you're not an employee, so you are under the Public Accommodations Act.
that throws you into whether we are an agency.
And they're, right, so I think with that one, actually, the Human Rights Commission has jurisdiction to hear complaints for a violation of the Public Accommodations Act. So it's not really a question of state agency or not. This is a place of public accommodation because it provides services and other benefits and privileges to the general public at large. And to you as members, there are particular advantages and
But that's what you
benefits.
pointed out that we have to.
Right. And so you'd basically have to be alleging that the conduct was of such a nature that it prevented you from enjoying the benefits and privileges that you have as a member. Most important of which is representing your constituents here in the State House and being able to effectively do that. The question that would come up, I think, for the Human Rights Commission or a court hearing that case is, are we getting into the inner workings? And is it running into a political question where this is a choice of how the chamber conducts itself under its internal rules? Or is this an issue of the General Assembly choosing not to provide One of the most common examples is an accessible entrance or something like that, where that doesn't get into how the General Assembly conducts its business. That gets into whether you're allowing someone into the building to actually do their job. So it gets a lot harder when you're talking about something where the speaker decides you're going to meet in one way, and the way you're meeting may expose someone to additional risk, like what happened in New Hampshire. But I think that would end up becoming a question that they would have to decide. You're not prevented from bringing that claim as a member at the Human Rights Commission. It's not clear until you know the facts of the case how the law would apply to it. And that's really the sticking point there. I don't think you can get around that with legislation.
Because it's really a separation of powers issue.
It gets into a separation of powers issue.
The courts, I mean, when you say political question, that's the courts saying this is a separation of powers issue.
Right. So when the courts do political question, they're saying this is not our business.
We can't, this
Yeah.
is the purview of one of the other branches of government. We
Right.
can't.
It's your exclusive purview is to govern the conduct and how you do the business within the chambers here. So you do get into this sort of gray area particularly with members. But there's also less of some of the potential sticking points for an employee are less existent for a member when you're going to a panel of your peers rather than as an employee where there may be a perceived power differential. And that power differential can be very different depending on whether you're a fairly new or junior employee or you're someone who's been here for a number of years.
And I think that's the point about the statewide situation, is that part of the influence or the intent to the bill is because some folks feel that there is a power dynamic with someone who is not an equal member, but a statewide office holder.
Right. The question is whether we have jurisdiction over that.
My second question was going to be, which jurisdiction over us are we talking about? Are we talking about the House of Representatives or the General Assembly?
So the way the Employment Practices Act or the Fair Employment Practices Act works is generally the subject for the lawsuit is the employing entity. So that would be the General Assembly as a whole. It can include an individual acting on behalf of the employer, although those cases and claims are far less common and often less easy to prove. So with the employer, it's pretty clear.
I
There's
guess
a manager acting on behalf. So like if I had a claim or another employee had a claim, the claim would basically be that the General Assembly did not provide me with a workplace free from discrimination.
I was just curious about if we were going to draft a bill, if we would draft it as it ourselves.
Yeah, I mean,
Which I guess isn't here.
yeah, I mean that gets into definitely more of a policy question.
Yeah.
And again, I also have to be clear. I can't, and I'm not advocating for one outcome or the other. This is just highlighting this came out of a discussion of what remedies are available, in part because all of our policies say you can contact the Human Rights Commission.
I wonder
But there is that ambiguity.
if it would be helpful to the committee if we all thought about it individually, but also maybe if chair or vice chair or others wanted to maybe make some different scenarios of what could go via some policy choices to kind of get the brain jogging for the sponsor.
I was just gonna say, I think really for us, just us now, although Damien, feel free to say I've misspoken. For us, I see three First of all, we have a legal question which they're going to write an opinion about, which is, can we even deal with constitutional?
Right.
I wouldn't be surprised if they conclude that we couldn't. The second, although it may be a different answer for the investigation part only, as opposed to the lawsuit part. The second issue is a policy issue, which is what's our attitude going to be for employees of the assembly, General Assembly, and ourselves, members of the General Assembly, really two different parts. And with respect to each, one option is do nothing. In other words, say the existing remedies that are available for each option are the remedies. We could do that. We could give full jurisdiction, consent to give full jurisdiction to the Human Rights Commission, or partial jurisdiction to the Human Rights Commission. The partial jurisdiction would be the right to investigate and make a recommendation to somebody here. And the other would be the right to their full panoply of their powers, which include the right to investigate, conclude, bring a lawsuit. That is a policy issue for us. Any other questions of Damien?
Good to see you.
I have a quick one. So would this be, if we went the route of giving jurisdiction to the HRC, would that be, eliminating the House panel
No,
option, or just as a
It would be
different?
another tool in the toolbox.
it would be
Additional.
providing, as I understand the bill, it would be providing an alternative avenue. So already, if I worked in the executive branch, my remedies are to bring a complaint within the internal mechanisms through the Department of Human Resources, to bring a complaint to the Human Rights Commission, or to file a lawsuit. If I work for a private employer, my remedies are to go internally through whatever processes are there, to bring a complaint to the Attorney General's office, or to file a lawsuit. And so what really came up in that discussion was that we clearly have internal processes set up here, and we have the option for a lawsuit. That third option of going to the Human Rights Commission, again, there's ambiguity about that. And so if you think of this bill, it's about, do you want to clarify the ambiguity as to whether that third option exists, knowing that there are already two clear remedies and there might be a third, although that may depend a bit on how that ambiguity is construed. So that's really where you're at here. So it's, yeah, you're not foreclosing other remedies. That would be a bigger question, and it wouldn't be appropriate for legislation. It would actually be a House rules change.
I request that you think about something.
Uh-huh.
I assume, I don't think you have to put it in your opinion, but I assume that should you conclude that we do have the authority, or partial or complete, to delegate to the Human Rights Commission authority over to investigate / beyond against a constitutional officer, what will happen next? In other words, I would assume that if we were to pass a bill such as that, the governor would request an opinion or something from somebody. And the question is, do we just let that happen? Or do we request an opinion from also beyond Ledge Council? I don't know. I just don't know how that works.
So I think your first step might actually be, before you pass something when the language is proposed.
Yeah.
Is having the potentially affected constitutional officers offering them the opportunity to testify or have their legal
Their
counsel
legal counsel,
testify
yes, but,
on behalf of them.
right,
And that, you know, it's,
yeah.
I always
think
like
that
to
makes
say, when you put three lawyers at a table, you're likely to get three very different opinions. And that, I think that is I think that is my experience with this potential ambiguity here. Is that when I've raised it with other attorneys, it seems like the opinions are across the board. And there are clearly strong arguments to be made. And I think that would really be your step. Similar to what happened when we looked at the state ethics commission or ethics panel. I forget what their correct title is, but I know that government operations committees took extensive testimony on the appropriate range of jurisdiction and remedies that panel could provide. And I'm not an expert on that panel, so I'm not going to try to lay out what those are. But I do remember that there was, weeks, if not months of testimony that went on that, and it went through a number of versions before they arrived at the final version. And I think it's since been subject to refinements. So that's something else to keep in mind, is that it does raise bigger questions. So
Okay,
from a workload perspective, this may not be a 1 week.
right, Daniel, what's your general time frame for an opinion on the Constitution? Is that,
I think we can turn it around relatively quickly, like not tomorrow, but
within a week, or?
within a week is probably reasonable
Okay.
to get at least an initial.
We're just trying to figure out our schedule. Okay,
But yeah, why don't I tentatively say a week
Okay.
and then touch base with my colleagues?
sure.
I know in my new subject matter area, we are starting to ramp up again after that brief respite.
What's your new subject area?
Transportation. So, yes, I moved to a very, very different subject matter.
Change is good.
It is. After 10 years, I was ready for a change of pace. And I know we're starting to ramp up. I don't know where my colleagues are at in terms of work, but I will reach out to everyone today, and then I can follow up with you if a week seems unreasonable. But
Sure.
my hope is that some of the heavy lifting has already been done, and so that this will be more of a.
When you contact me, will you CC Magali, please?
Of course.
Thank you.
Yep.
Any final questions? Damien, thank you so much for taking the time.
You're very welcome. I did hear from my colleague Cameron that there were some questions about the smoke.
Oh, yes.
alarm
Well, we
requirements.
just don't know what the hell it is.
I can explain it really quickly.
Good.
So essentially, back in the day, when we first adopted the smoke detector requirements, many of you will probably remember this. There were a lot of detectors that would go off you would sneeze and the smoke alarm would go off. So Vermont adopted a photoelectric only requirement because those had less false positives. Since then, technology has come a long way. And the underwriters laboratories who issue the standards here have updated their standard pretty consistently since then. And so the UL standard 217, I think it is, compliant smoke alarms, they use both photoelectric and I'm forgetting the other type of sensing technology, but they now use the multiple sensing technology that used to have a lot of false positives. It's been refined, so those numbers have come down, and it's considered to be safer now than the photoelectric only. They're also designing them now to detect the difference between like a shower and smoke from cooking, a smoldering fire, a hot fire. These sensors have really been refined in the last couple decades. So that's all this is doing, is just allowing compliance by either using the existing photoelectric only or the new UL 217 compliant alarms, which is the majority of what's on the market. And so that's just bringing us up to current standards. That's all it's doing.
Do we have one in this room?
So you, right up there, is your
Okay.
smoke and heat detector. And then all of these discs on the ceiling that are blank are sprinklers. So, yep, every room in this building has got a detector and sprinkler system set up. So, yeah, you actually, I mean, our fire alarm system here at the State House is also quite sensitive. But I think part of that's because it's a very complicated system in an old building that has a lot of issues outside of that make modern electronics struggle. Yeah, you do have a modern system. I don't know if that's UL 217 compliant. I'm guessing it is, because of the fire code for commercial buildings and public buildings. So the difference here is those smoke alarm requirements are for residences. And so basically when you sell a residence, whether it's new construction or old, you have to certify that you've got smoke detectors. There are different requirements for old houses and new construction, but this is allowing you to comply with either the photoelectric only or the UL 217 smoke detectors, and then the other requirements, which, so like a new house, you have to have them in all the bedrooms, on every floor. In old houses, you just have to have one near the bedrooms, et cetera. And new houses, they have to be hardwired to the electrical system with battery backup, and they need to talk to each other. So if you have a fire in the basement or smoke in the basement and you're in the furthest bedroom upstairs, it will tell you that, they'll all go off. The old ones don't have to do that. So yes,
You never know which one it is.
Which one's going on.
yeah, they're,
Have they figured out that people are destroying their smoke alarms at an alarming rate in 3 in the
So,
morning?
yeah, that is one of the reasons why they're updating too, is to just keep up with the newest options out there, which are getting less prone to these false alarms. But yeah, I'm right there with you, having had them go off in the middle of the night. And then trying to figure out which one it is that's setting off all of them and what it is. But yeah.
Can I ask a question?
Sure.
How did you come to be the go-to guy for this?
For building codes and fire codes?
Yeah.
And do you want to get on a universal design committee?
No, so no, I don't want to be on a summer study committee, but and no, it wouldn't be appropriate for me to be either if I have to be really serious about it. But I prefer to spend my summers doing other things. Because I've staffed the general committee historically, this was a general committee issue. And I happen to be one of those people who finds the building and fire codes fascinating. So I kept it as an issue when I transitioned out of my old role. So I love understanding the codes and why they are the way they are. I find that very fascinating. So that's just how I am as a person. So that's how I kept it.
Got it.
But yeah. Don't you guys find UL Standard 217 fascinating?
Damien, I would like to know, I have smoke detectors in every room.
Okay.
And so, when they go